Good evening, everyone, and welcome to the Legal Contracts and Policy Board Policy Committee meeting this September the 15th of 2025. I am going to open the meeting. Is there any questions in reference to the meeting minutes? Any questions to meeting minutes? No questions for the meeting minutes. Any public participation? Anyone wanting to speak to the committee? Anyone wanting to speak to the committee? No one wanting to speak to the committee, so therefore we'll go right into our meeting. We'll turn it over to our attorney to move forward.
Good evening, Vice President Alexander. Thank you for your time, members of the committee. We're here to address some current policies, but I'll give you a little bit of background of what we're looking at tonight. As you probably are aware, House Bill 96 was passed by the state legislature, and then as a result of the passing of the biennial budget bill, there are additional policies and language updates that are included moving forward in that process that the state legislature passes on to the school districts. Then in the month of August, in the second half of August, the company that we work with, the district, Neola, reviews and parses through the legislative language and then provides necessary update language on particular policies for school districts across the state. So tonight, we have identified 4 policies in the recent Neola update that will take effect at the end of September 30th, after the governor had signed this bill into law. So the first 4 policies, again, are policies that are becoming effective September 30th. They involve policies that currently exist for the district and are revisions. So we're not putting forward new policies in these first 4 that we'll discuss tonight. We will also have leads from the district on particular policies to provide answers to your questions if you have any, and provide information as to what policy is under consideration. Because the fact that these policies become law September 30th, we're also asking that we will take a first read. Our objective is to take a first read through the policies this evening, and because of the impact of the September 30th date, to request that these be moved to the board meeting next Monday, September 22nd, for consideration.
Thank you. Can we go ahead to the first policy?
Yes, sir, Mr. Vice President. The first policy will be 3.02, and that will be policy 6830, the audit policy and update, and that will be addressed by Treasurer Bowers.
Good evening. Policy 6830 is called the audit policy. Current law requires the treasurer to produce an accounting of all the money every year, which we do annually as an audit. What House Bill 96 changes is that when the treasurer changes office, so if somebody resigns or comes in, we could have the state auditors come in and do an accounting for the bank balances, the book balances. We can no longer delegate that to the auditor's office. So after September 30th, this task has to be performed by either the board or a committee of the board. That's the only significant change I see to the policy. Are there any questions?
Any questions for Mr. Bauer in reference to the policy? No questions? Okay, let's move on to the next policy.
Thank you, Mr. Vice President. Next policy will be policy 8462, student abuse and neglect. It's an existing policy, and again, this is an update from the House Bill language from House Bill 96, and we would invite Ms. Yvonne Culver to speak or answer any questions on this update.
Good evening, Madam President and members of the board. This policy, once again, has just been updated to reflect the changes in House Bill 96 with the compulsory training for sexual abuse awareness for students in K through 6 at a developmental level, and then in grades 7 through 12 once again at a developmental level to include instruction on inappropriate relationships. We are already in compliance. There are things there that speak to who needs to be trained, and so we are already as we said, in compliance with the changes. The policy will just now reflect that.
Any questions? Pastor Harrison?
Thank you, Mr. Chair. As the policy read developmentally appropriate instruction, can you explain developmentally appropriate?
So we are looking at the grade level. So I'm not going to talk to a kindergartner about appropriate touch in the same way I would talk to a 5th grader, even though it's elementary. So the counselors have lessons that they do on good touch, bad touch, but it's more applicable with language and with delivery the higher up you go.
Okay, so let me try to ask it. Let me try to clear it. The counselors have I guess I'm asking, the person who is providing this, they kind of, this is their area. They know. Correct. This is right. Okay.
Correct. And then we also work with area agencies if we feel that it's, like if it's a brand new counselor, okay, we'll work with the area agency to make sure they're trained appropriately.
Okay.
Any other questions on this policy? No more questions? Okay, thank you, Ms. Culver. All right, next.
Thank you, Mr. Vice President. Our next policy will be Policy 5223, and that is release time off for religious instruction. Again, this is an existing policy that has some updates pursuant to House Bill 96, and our individual to help address questions will be Dr. Wanda Lash.
Thank you. Good evening, President Jackson, Mr. Vice President Alexander, and members of the board. So this policy, release time for religious instruction during the school day, you may recall when we first saw the House bill analysis for 8, if I remember, way back when, maybe a couple months ago. And so this was about excused time from school to attend and identifying a time of the school day. And so with these revisions here, really, I'm going to scroll down here. In this middle section with the green, the biggest change here is identifying that for elementary and middle school students, that it would be 1 period per week, and for high school students, the equivalent time would be 1 unit of high school credit per week. And we did select an option here that the board deems all graded courses to be core curriculum, because per this policy, students cannot be removed from core classes in order to have their release time for religious instruction. And so that's the biggest change here, okay, is identifying the 1 period and 1 unit of high school credit per week.
Okay. Thank you. Any questions? Pastor Harrison?
And thank you, Brother Chair. I'm looking on page 3, and it was in there, but I don't know, it stands out now. Non-educational or non-program related materials, however, are not permitted to return to school. So if they're responsible for transporting, if they go off-site, they're responsible for transporting and coming back. Do we have something in place that, can they bring the material back if they receive it? Is this saying they can't bring material back, or is?
Do you want to speak to that?
Sure, Member Harrison. Thank you for your question. Yes, the lead sentence in that paragraph you're referring to allows if they receive material, educational and program materials during their religious instruction, they can bring that back.
Okay, okay.
Any other questions for Dr. Molnar?
Thank you, Member Alexander. I have a few questions related to the state law, and I don't know if they've made their way or if they need to make their way into this policy, but I am curious about some of them. So I do see that the parental consent is here and that the sponsoring entity maintains attendance records and that they assume liability for the student and that the student assumes responsibility for any missed work. Is the off-campus requirement in this policy somewhere? And the no public funds in this somewhere?
Wanda?
Repeat that one more time, Dr. Molnar. Is the
Off-campus requirement and no public funds.
so not? I'm just writing it down. So if we need to go back to it, not that I can recall. And do you mind saying more? So when you ask about the off-campus requirement, like what are you?
So the students must be taken off of APS property.
Right.
This cannot occur at one of our buildings or in one of our buildings. So that's the off-campus requirement.
So an explicit statement that calls out that it's off-campus.
That it, yes, it's
Okay.
listed as one of the key components of the law. And then also that no public funds can be used, which is why it can't be in our building.
Sure.
So when you look at the
Yes.
first page, Member Molnar,
Yes.
transportation of students after A, B, C, and D to be from released instruction is the sole responsibility of the sponsoring entity, the parent, guardian, and/or student.
Does that speak to what you're, or
Which are
It is a solution to, but if they don't go anywhere, there's no transportation.
this
And so they
policy
need
is
to go
release
somewhere.
time, yes, for religious instruction. So this is allows students to be released and leave Akron Public Schools for religious instruction.
Okay.
Madam President?
Yeah, it just, it also says no board funds will be expended for or no district personnel shall further, no board funds will be.
First page.
thank you, President Jackson.
Yes, Reverend Harrison?
So I think, I don't want to speak for her, but I think it was, the language was looking specifically to spell out no public money will be used for religious instructions. And so we can imply certain things in the policy, but as I said before, when we're doing a policy, if we're going to take the time to do the policy, let's make sure that we get not the inference in the policy, but get the language in the policy. And so I think what we're speaking about here is to spell out that no public dollars, and I think we all hear this all the time about the public dollars and the religious in our schools. So to just kind of spell it out in the policy, is that problematic? Is it not?
I'm going to go ahead, Dr. Molnar, go ahead. I'll let you.
So, because it does say no board
Right.
funds, but are there other public funds besides board funds? I don't know. I don't know if everyone knows, but if we just said no public funds instead of no board funds, that would really clear that up.
We can't go beyond what we are. We're a board of education that we have our funds that we're entrusted with in the school district. So by saying, no board funds, that speaks for the district in the public funds.
And I guess where I'm going with this, and maybe how I should have started with this, is it's release time, but if, for instance, a student is released to a library or released to another area of the building we have, and I am thinking of a lot of things right now, they are not necessarily out of the building. We do have some buildings where we have multiple entities in the same building, and so some of those entities are using public funds that are not our funds. I don't know if that is
Right.
relevant.
Again, yeah, I think you're kind of touching on a related, maybe parallel item, because again, this policy is conducted by private sponsoring entity policy. It addresses, that's what this policy addresses, release time for religious instruction during the school day. If you look at the first full paragraph, off district property, that's what this policy is addressing.
I'm going to ask a question too, just to be safe a little bit. I want to make sure, when we're talking about this here, I know there's a piece that said church and state, okay, that you got to keep them separate. So it sounds like to me, and you guys tell me if I'm wrong, but it sounds like, the church and state piece. So they can't not have religious instruction on public grounds in public schools, but they can go outside of that, the building, and have that. So we can't use any funds for transportation. We can't use any funds for the teaching of the classes, those type of things. So we can't use the funds for that religious instruction because that's part of the state piece. You guys tell me if I'm wrong or not. I want to make sure that's correct because I know for a long time, the state has said you got to have a division between church and state. So you guys maybe let me know if I'm correct or if I'm wrong.
Yeah, no, the policy, again, has been vetted and reviewed by the outside counsels for Neola, for administrators as well. And this is the language per this requirement of House Bill 96 that is to be put into this off-site religious instruction policy. Sorry about that. Yes, this is the language that was, again, been vetted by the outside superintendents, administrators, outside counsel for Neola that addresses off-site, as you mentioned.
So this is requested language they state we need to have in here
Correct.
to protect church and state.
Yes.
Dr. Mona, I think you had a question.
Thanks. Yes, and can I have one more thing? And thank you for going through this because we didn't, as a committee, read through this whole thing. It's up here all at once. So I saw the crossed off part and not the moved part. So then my last comment here is at the very end of page 1, the bottom of page 1, where it says the board deems. My recommendation for language here is, yes, it's green, you just went past it, is that the board deems core curriculum as including but not limited to courses aligned with state-approved learning standards, grading courses, and other learning experiences identified as core curriculum under board policy. So it has most of that, but it rearranges a little bit and then also recognizes board policy.
Okay. Can you make sure I get that, Dr. Mona? Okay, thank you.
Any other questions at this point? Okay. Thank you, Dr. Lash. Appreciate it. And next.
Okay, Dr. Lash, don't go too far. Our next is policy 5410, and that is promotion, academic acceleration, placement, and retention. Again, this is an existing policy, and there are language updates pursuant to House Bill 96 for consideration.
you, Ms. Moika. All right, so this policy, promotion, academic acceleration, placement, and retention, has a lot of housekeeping cleanup, if you will. So you'll see strikeouts of his, her, and that being replaced with the student. You'll also see an additional section here for academic acceleration. That really kind of speaks to the process and the committee. You'll see the cleanup again. I pause here for the principal being capitalized, but you'll notice right here at the top of page 2 where we had the option of selecting that if a change happens, if a student is being accelerated and there's a change that occurs, that we would do that at the grading period versus waiting for the semester. So you'll see the choice there. And then moving down on page 2, you'll see Department of Education with that addition there, and workforce, the Ohio Department of Education and Workforce. Again, some cleanup of the language. You'll see his, her designee removed. And then here, again, page 3 in the retention section here, again, that cleanup of his, her replaced with the students. And you'll see here in letter A, striking out mathematics and reading and saying the course subjects, listing out mathematics, English, language arts, science, and social studies, naming the 4 core courses or core subjects. And then here, I believe that's the top of page 4. Again, the cleanup of language, and you'll see in letter D there, the strikeout of the truant for 10%. That was a change, that a student cannot be retained because of the truancy, but you'll see that language there has failed at least 2 courses of study. Okay. And those are the changes with the promotion, academic acceleration, placement, and retention policy.
Any questions for Dr. Lash? Pastor Harrison?
I have a question, and if we can talk about it after the meeting. It's dealing with the acceleration on page 2, but it's not going to be impacting the policy itself. It's probably administrative guidelines that we would find that in. So I don't want to hold up the policy portion of it.
Okay, thank you. Any other questions on this policy? Okay, if not, let's move on to the next policy.
Thank you, Vice President Alexander. Dr. Lash, one more, please, if you would. Policy 5780.01, Parents' Bill of Rights. My understanding, again, is this is an existing policy that was recently approved, but also put on for the committee's consideration with some additional language that has been now included in the version, I think, that Dr. Lash is about to talk about.
Yes, so I know everyone remembers the Parents' Bill of Rights, 5780.01. And so we think we got it, but I will look at you all to let us know. The last time we met last month, we talked about what had been added. So you'll see here on page 1, the strikeout about the investigation. Kind of took us a minute to have the same understanding, and therefore added this sentence that you see highlighted in green. So let me back up. The paragraph where you see the strike through with the investigation language and you see in green experiences any substantial change, we talked about that last month, so that it is just staying there because it hasn't been adopted just yet. But the additional sentence that we added, again, once we got some clarity there, was should there be disagreement regarding the provision of services, parents will be notified by school administration through email and/or telephone conference.
Any questions? I see some.
I have a question.
Pastor
A
Harrison?
statement, a question. This additional sentence that we've added, and I think we've had discussions, loose discussions, with notification processes, and because we're talking about changes, and because we're using language like substantial, the notification by email or telephone conference seems to be not adequate. And I say that because we have had, if we're going to use language like substantial, and whether it's a 504 plan, IEP, or whatever it is, I think that we need to be doing something stronger than an email or a telephone conference. And so if that's in the policy and we miss that, and I'm just thinking of some recent occurrences, this may not go strong. This may not be strong enough in a policy.
Dr. Molnar?
Thank you. And I remember from the last conversation that it was not when there was a substantial change and there's a disagreement regarding the provision of services. How can I disagree with the provision of services if there are no services and I don't know about it to begin with? And the whole point and the goal of the conversation was how as a parent do I know about this to begin with? And so I thought it was when school staff become aware, the parent will be notified. And then there might be a change in services, there might not be a change in services, but we would notify the parent when school staff become aware, when there is a report.
So at our last meeting, when we talked about like a conflict, like, student wants services, but school does not think student needs services, that there would be communication. And so that sentence speaks to that. Should there be disagreement regarding the provision of services, so regarding even providing them, period. So whether you have them or not, that's not captured, that's irrelevant here in this sentence. This sentence is about that there's a disagreement regarding whether you should have them or not. So we thought that spoke to the conflict that we talked about last time, that if a student wants services but school says we don't think you should have services, that there would be notification to the, hear what you are saying, Reverend, that if we're talking substantial change, does email and or telephone conference, is that strong enough? But before we get there, Dr. Molnar, if that doesn't communicate that explicitly, if you've got some suggested language, because remember, going further in the policy does talk about the substantial change. So if there is a change to the services that you're provided, there will be notification. And I know Attorney Sapusik can speak best to this, but this policy is about the notifications when those changes and those things occur. And so the substantial change, yes, notification will happen, but even if there's no services being provided, but I, as a student, want services to be provided, and I request them, that's what we were hoping that sentence would communicate, that we would then be notifying the family.
You look puzzled there. Go ahead.
No, I was just saying, again, I wasn't privy to the prior discussions and considerations of this policy prior to my arrival, but I was just going to speak briefly to Member Harrison's statement about the special education and the IEP piece. There's a lot of regulations and policies already in place that require the district to proceed through specific notifications, conducting parent notices and things for special education and IEP outside of this policy.
Thank you. I appreciate that, and I will put back on the table what I have previously stated in this committee. We may have some redundancies in policies, language, but it's no reason not to put it in every policy, even if it's found, we're speaking in generalities in this policy. And based on the conversations that we've had, again, looking at policy and saying, well, that's found over here in this policy, or that, if we're dealing with this situation, it's found over here in this policy. When we're looking at policies, because it's found somewhere else does not mean that, I shouldn't have to find 4 policies to find one avenue of, I shouldn't have to look in multiple policies to find out what should happen. If we're looking at creating, sustaining policies, and we're looking at this issue here, then I think whatever is prescribed should be in this policy. And even if the language is in a different policy, whether it's a IEP or a 504 policy, when I'm looking at this policy and it says substantial change, then I would think that there's a substantial effort for notification, and I'm not sure. I guess that's what I was speaking to. If we use substantial, which means that it's an impactful change. It's a big change, and I think that language that we use at the top should say that if we need to notify someone, it should be a substantial effort to notify them. And I'm just not sure that email or a telephone conference rises to substantial, if that makes sense.
I'm going to let Ms. Culver answer, but I had some thoughts on that too. Because I want to chime in.
So I think in practice, those are the 2 ways that we are most able to reach parents and then continue the services without putting the child in limbo. We could possibly add and through email and or telephone or in-person conference if you want that as an option. But if we wait to have a face-to-face, a lot of times we are holding up services because it could be a transportation problem with a parent. But the goal is we are going to contact them. Those are just the 2 most convenient ways we find for our families.
Yeah, and I wasn't speaking so much as to the hows, but I was speaking of the urgency of the matter. So, you can have email, telephone, but something, because substantial should require immediate. So, and now we're getting into time frames, I know, but I'm saying that we kind of need to close this loop because we're talking about a substantial change. So if we're saying email, telephone conference, I would be okay with saying immediately notify a parent through or by or in addition to. And I don't want to box us in, but I also want to be respectful of, we're talking about a substantial change and we're taking a substantial effort and action.
So may I ask this question, Member Harrison? We added, remember when it said promptly and we added the within 2 school days? Is that what you're thinking? Like maybe putting a time bound here, be notified by school administration immediately.
And I don't want to put something in there that's unreasonable, but I just want to make sure that we are addressing, if we put promptly up at the top, but we need to address that we're saying something happened substantially, and we need to make sure that, the policy reflects that we've taken action because there's a substantial change. We've been consistent with that. So I appreciate that. I know we had discussions on that last meeting. I'm not sure if I'm making myself clear.
I'm gonna get in here just a little bit. I think when we're talking about this here, and it's substantial, I think I'm hoping that everyone's professional, and it means if we need to contact a parent right away, that we would do that. And so we would try to contact most of the time is by phone. There's sometimes you may not get them by phone, you might be able to get them by email. I think also, and you guys can correct me if I'm wrong, staff, that may be an administrative guidelines, a step-by-step. So I'm going to call this person here. I'm going to document that I called them on this date and this time. I'm going to email them. Email shows the date and time, but I'm still going to document this here. If I had to send someone to the home, I'm going to document that I sent somebody to the home to go out there, so we're covering ourselves. So we're immediately doing this here at the same time of covering ourselves. I don't know if that's an administrative guidelines or not. You guys would have to tell me, but I would think that would be part of administrative guidelines, because and this is my personal piece of doing policies for a number of years. I don't think everything needs to go into a policy, because like you said, we box ourselves in. I like that Akron Public Schools has administrative guidelines, so that's a step by step. And that shows if this is going on, here's my step that I should do, take these steps. Now, if I'm not taking those steps as the person who's supposed to be in charge, then I'm not doing my job. So I think that's where it may be. And you guys tell me, I'm looking at people who are here, if that may be an administrative guidelines. I don't know. Madam President.
So looking through this point, also I'm referencing back to what Member Molinar stated as far as once the staff member has knowledge of it, immediately contacting the parent, because of the gaps that happen with that. So if my kid comes to school and says, I don't need to go to tutoring anymore, I don't want to go to tutoring anymore, and you can't physically force certain kids to go to tutoring, then the parent comes around and say, why is my child no longer getting tutoring? I see in their grades, they're supposed to be, I signed a Title I form and they were supposed to be getting tutoring, but the middle school just said, I'm not going, right? And so the parent was unaware. You know how those things can go. But the one caveat is what I was thinking is, should there be disagreement regarding the provision of services, parents will immediately be notified by school administrator via email, teleconference, because it's just putting that like it's an immediate note. So once I'm aware, then an email, it just becomes a standard operating procedure that we immediately notify the parent via email, because then it puts the responsibility on the parent for those vessels of communication that they put, just because that's what it sounds like I was hearing from both Member Molinar and Harrison, is just to put that one word.
Yes.
Immediately notified, because as soon as I become made aware as the principal, if the tutors come and tell me this child is refusing to go to tutoring, that is just there, is what it sounded like to me.
So is that what you guys want to have, Dr. Molinar?
Thank you. Yes, I like the direction that this is going, and I understand that we have administrative guidelines. I know we discussed maybe even bringing the administrative guidelines at some point, and because I know IDEA has recommendations, and we can assume that our administrative guidelines are that, but we don't know, and that's why we're putting it into policy, because also it can change, but if it's in policy, it won't change. And so with the Title I, which is a great example, and thank you for providing that example, or not title, the tutoring, because there could be a disagreement that the student thinks they don't need tutoring, but the school thinks they do need tutoring, and that's a disagreement there, and so now we're notifying families as a disagreement. But there might be instances where there isn't a disagreement, and so my concern from the very beginning of this is because we are really focusing on notifying parents about changes in mental, emotional, physical health.
Right.
And the mental health component of it has been where I'm trying to think of how can we make sure parents know what's happening with their kids. That's always been my perspective. And so I'm even thinking, let's say, for instance, there's another student who notices something about their classmate, about their friend, and they inform a teacher or a counselor or someone, and then it is determined that there's no substantial change, nothing's going to be done. As a parent, I still want to know that. I want to know that this classmate is concerned about my kid. I want to know this friend, and because maybe it isn't a substantial change yet. Maybe it hasn't grown to that yet. But as a parent, there's still something I can do at home. There's something I can do, at dinner or over the weekend or with the grandparents that can make this better, even though the school does not need to provide a service for this yet. And so those type of experiences are why I think as President Jackson and Member Harrison were saying, just as soon as staff become aware, when staff become aware of a physical, we have mental, emotional, physical concern. When staff become aware, the parents are notified. And that's cut and dry. You know about it, you don't know about it. I don't have to determine how big of a deal I think it is. I know about it, I'm going to tell the parents. Thank you.
So we're saying no immediate in there, or immediate in one place, and then we're putting something else somewhere else? I just want to make sure I'm clear, too.
No, I think we can be consistent with the language. So I wasn't trying to think of a word. I'm just saying let's be consistent with, immediate. If we're going to use immediate, let's be consistent with immediate. But I think this is kind of the reason why we're making some of these changes while it's in the biannual bill is to empower parents with information. And I think if we keep that in the forefront, then we will kind of be on track.
So what language do we want? Are we saying with Dr. Monar? It sounds like if everyone's agreeing upon that, then we can probably put that in there, because it sounds like we were saying immediately at first, but now we're not saying immediately. So if we're saying notify, can you say that again, Dr. Monar, how you said that?
Immediate is in this policy. It's just further down. And we're saying just be consistent.
Promptly. I was going to ask that question because we were
Yeah.
using the word immediate, and I heard what you said, let's be consistent. So do we?
Whatever you guys are using is fine with me, as long as it's.
I'm okay with that, too. I mean, I just
With
want to make sure
promptly.
we have the right language that everybody agrees upon. Okay, so we agree upon promptly, then we'll put promptly in there.
Okay.
Dr. Monar?
Did we have the number 2 days in there somewhere also?
Yes, it's, that's what
Yes.
right here.
Yes, school district personnel will promptly defined within 2 school days. So if we use promptly in the top, it will still mean within 2 school days.
All right, so all minds clear?
I feel like I have one more question,
Yes, go ahead.
Mr. Alexander, just to be sure. So with what Dr. Monar mentioned, is there, so I got promptly, we'll add that. Is there also a request to add another qualifier or descriptor? I just want to make sure we got it all.
She's asking you, Dr. Monar.
Yes. So, and I will email this to you with the other last one too, but I think we were saying when they become aware.
Okay,
Okay.
When they become aware.
got it, perfect.
All right.
All right.
Thank you.
Any other questions on this, for Dr. Lasher on this policy? Okay, if not, let's move on to the next one. That's some good work, good work.
Chair Alexander, we are now entering Section 4 of the committee meeting, which would be new business. And that would be 4.01. This is a policy, my understanding, that has not yet been introduced to the committee. So it is policy 9800, the posthumous and honorary diplomas policy. And so we have Angela Carter here to speak on that and provide background on this policy.
Okay, yes. So this was requested by the board that we put something like this in place. So this is our first attempt at this policy. And originally, the district had Section B as in this policy, and we did not address posthumous piece within our policy with APS. And so we're proposing that we call it posthumous and honorary diploma, posthumous and honorary diplomas. Before it was called high school diplomas to World War II, Korean conflict, and Vietnam conflict veterans, because we just addressed veterans. And so it reads, the Board of Education values the dedication and service of its students and community members and wishes to recognize individuals who were unable to complete high school due to extraordinary circumstances. The board authorizes the issuance of posthumous or honorary diplomas in the following circumstances. Students who are deceased, to honor students who died while enrolled in the district or who experienced significant hardship and were unable to graduate. The board, superintendent, or the director of family and student services may award a posthumous or honorary diploma. This diploma is symbolic in nature and carries no legal rights or benefits. Example, it is not considered equivalent to a diploma earned by meeting graduation requirements. To be considered for this diploma, the individual must have been enrolled in the district at the time of death or experienced a significant hardship that prevented graduation. A written request must be submitted by a parent or immediate family member of the deceased student. The request must be received by the last business day in March of the school year in which the student would have graduated. The request must be submitted to the assistant superintendent and include any relevant documentation that supports the request. The decision to award a diploma is at the discretion of the assistant superintendent and the Board of Education. And then just a few changes based on what was in the old policy. So changing fight for to serve, crossing out all of and putting under the provision, and then enrolled in any high school in Ohio instead of saying this state. Crossing out either and putting the veteran left a public or non-public, crossing out in order, adding the word or on that first bullet under A, to serve in the armed forces of the United States, or due to family circumstances, and crossing out of the United States and just leave it at armed forces. And then a few more correct cross-outs down at the bottom. The board will award the diploma posthumously and present it to a surviving relative. And then note the other crossouts down at the bottom. The board may award this diploma upon receiving an application and appropriate verification of eligibility from the Governor's Office of Veterans Affairs. And then applications are available through. So again, this is our first attempt and a rough draft. So feedback and any changes or modifications.
Questions or feedback? Ms. Autry?
Thank you, Chair Alexander, and thank you, because I know this is something that I was certainly advocating for. It's unfortunate that we have to have this as a result of us having violence in our community. It was brought to my attention about, several students we've lost due to violence wanting to be recognized. So I appreciate this opportunity. My comment is around section number 3 on the first page. And I'm thinking about students who may have already, their graduation date might have already, passed us by. And so I think we should kind of tweak that, because we might have someone, whose graduation year was in 2020. But now that we have this policy, we can acknowledge those individuals. And then also, and I don't know if this is more of an administrative guideline, but I would anticipate the community having questions, understanding that this is honorary, this is not an official diploma, but I'm sure folks would ask, well, is my child's name going to be in the booklet, at graduation, or will their name be mentioned at a ceremony, or is that going to be determined at the building level? So those are just, I'm thinking out loud of anticipating what I might hear from families who might be interested in this.
Okay, any other, Pastor Harrison?
I have a couple, and I think they probably would be better served to email them, but when we move into Section B in the veteran section, because it specifically lays out conflicts and or wars, we've moved into now at least 3 times as many from this last one. And then there's some language in here that kind of specific to veterans that I think we can maybe look at to be more inclusive. So I'll email those. I'll email those within this policy. I am curious when we are talking about the violence within our community and the students that we have lost. And I don't know that we can nail it down I don't know if we can zero it in any closer, but it kind of seems vague. Will there be administrative guidelines to this policy? Because I understand we can't put everything in this policy, but I guess I should email it. But it's kind of, every situation is not the same, and so if I'm asking, well, I don't know if my situation fits. So what's the process? And maybe that's what it is, to find out if my specific situation fit, and then I can look, and there's a process, because you can't put the process in the policy, but the policy is kind of vague to, it's specific in veterans, but it's vague to community, the students in the community.
Okay.
Madam President?
Okay, this is, because I'm trying to see that I misunderstand. So I thought Part A was for community and Part B, but the Part B, the Part B about veterans, because in order for them to be is this just reference point? I guess that's what I'm going to say for Part B. Was reference language to Member Harrison's point? Is Part B just reference language? It's nothing to do with the military, correct?
Part B
It's
is
for
ORC.
someone that has passed away that served in the military.
Yeah.
Right, but because I'm talking the posthumous diploma. If they're in the military, that's why I'm trying to. It's separate, because if you're in the military, you already have your.
No.
That's not. Oh, okay. I just learned something. So you don't have to have a GED or a diploma to go to the military now. Yeah, this is something new for me. Good. I like learning new stuff.
Good for me too. I didn't know that.
So that's why I was thinking that's why when Member Harrison started talking, I was like, well, wait, I think I am understanding this right, or in 2 parts, but I don't think so. Go ahead.
Good evening, President Jackson, Vice President Alexander, and members of the board. The actual one with the veterans was at the time that we had the draft in action for World War II, Korea, and the Vietnam War. Right. And once students or young males were drafted, they had to leave in the process and did not complete high school. It is very specific through the Veterans Affairs as to who is eligible. So now we have a volunteer service at this point, and they have not added to your point, say, the Iraq conflict or other wars. It's very specific as to how we get this information, as to who qualifies, and once we get a request, we work through the Veterans Affairs Department to see if we can allow that to be awarded. So we've done this exactly twice, one of which was a gentleman who was drafted out of World War II, and his family asked on his behalf, and it was determined he qualified, and they flew in all the way from Hawaii, and he actually graduated with a class of students at Ellett. So that's why those specific conflicts or wars are listed, is because that's when the draft was eligible to take people prior to allowing them to complete high school. At this point, you are correct. You do need a high school diploma to be eligible now to go ahead and apply for the military, which is part of our college and career model of having students be ready to go on to post-secondary employment, education, military service. And they take very specific tests to not only show that they graduated, but they also earn the offer from the military. And that's why we're very fortunate to have our 4 ROTC coordinates here. We have one for Army, one for Navy, one for Air Force, and one for Marines. And they help them get ready for those applications.
Excellent.
Thank you.
Thank you so much. That was my question. So now it takes me back to my original, that this part is just for reference, because you couldn't be a veteran without already having a diploma currently in our currently. And so that's why I was thinking, until Member Harrison asked his question, that Part B was just a reference point, like all the veteran stuff it was just being looked at for possible language for the posthumous diplomas for students who, I know we had one lady presented to us, I think her child might have became deceased in the 7th grade, and then another one was in high school. So this is what this is for, because we wouldn't have any that people who would demise in a conflict, military conflict, even if we updated, that wouldn't have a high school diploma. Is that correct? Because Member Harrison was saying that some of this stuff is towards veterans, and I'm saying, is this just for language? We're clearly going to take the veteran information out, because this wouldn't apply to veterans. That's my question. It wouldn't apply for what we're trying to change.
So because this is the first draft, I'm looking at this as an A section and a B section. The B section is already contained in the ORC.
Yes, it's already on our books as policy.
So the B section is we're not replacing B with A. This is A, B, correct?
Yes, adding A to the top of.
Yes, okay.
I thought they were,
Yeah,
good.
okay.
Thank you for that, Member Harrison, because that's what I was wondering. Are we taking information from B into A? Like, what we're using as a reference point for the posthumous diploma? That's what I was asking, but it's just to add on to. Okay, I'm clear now. Thank you.
Mm-hmm. So when we were asked to work on this policy, we looked at what policy do we currently have, and right now we have 9800, which just addresses the veterans. Mm-hmm.
Thank you.
Okay. Any more questions? I do have something. I said, and Ms. Carter, if it's okay, if board members have something they want to, or some suggestions, can they email them to you? Because this is a working document, still just first piece, to be able to put it in and work what we need to, and come back till we get to a point where we have a solid policy.
Yes, if they could email Attorney Sapusik.
Okay, I'm sorry. So email our attorney. Any suggestions and thoughts, and we'll just weave it on in where we can to try to develop this policy, because it is new, and I'm glad that we're doing this. And Ms. Autry, thank you, because you pushed this for a lot, and we needed to have something like this here for others as well. Okay, any other comments for this policy? Okay, we have about 4 minutes. I don't know if we want to start anything else, or you guys have something you can do in 4 minutes. If not, we will stop right here.
Not in 4 minutes, Vice Chair.
Okay. Do we have any other comments or something anyone wants to talk about before we end? Pastor Harrison?
Yes, it's been a long meeting, long 2 meetings. But the vendor relations, we've been working on the independent contractor, and that policy has been kind of pushed to the back, and especially now that we've had recent a lot of conversations about vendors, and I really think we need to look at that policy and get some clarification, or pass that policy so that we can have a guideline that everyone can see. The policies are not just for us, but the public, if they want to come and address us at a certain time, they need to be able to understand, okay, there's a policy, and you can look at the policy. It may be something they thought should have happened, didn't happen, or maybe something didn't happen that should have happened. But the policy is not just our policies, but for everyone to see. So I would really like to see us move that policy or start to work on that policy.
Okay, that was one of the part of our discussion when we talked to attorneys. Since these are something they had to have by the end of this month, and our next meeting will be the last one before the end of the month, that we get these done first, because they're saying that we need to have these done, and then we're moving the other ones up to try to get into more discussion. Because that's one that we want to have a lot of. Well, I'm sure we have a lot of discussion. There's a couple others that we would have a lot of discussion about. So we want to make sure we have enough time, to do that. So thank you for stating that. Dr. Molnar.
Thank you, Member Alexander. I agree that there are policies on the back burner. It'd be great if we could move them up. I'm glad we're bringing new policies in, because I know that these have been important to our members also. As regarding the actual vendor policy that's here, I know that there are technology statements and technology requirements, and that is related to some things that we have to pass, we have to put in for our own security. In addition to that, when we do discuss this, I want to know about the web content accessibility guidelines, and if the vendor contracts are going to state their obligations, or is it our obligation, and what we're going to do as far as compliance goes, as we have that April deadline that we need to have that accessibility. I'd like to know in here who's holding that responsibility. Is something that'd be really nice. And then the public complaints policy, I feel like I know why we feel like we need this. I do feel like a lot of this is kind of redundant, but I'd like to know when this is presented from the author, kind of where this came from. So not why do we have it, why do we think we need it, I think we all know that, but the other policies that were looked at in order to grab this language, and other maybe similar institutions that have policies like this, and how they use theirs. Thank you.
So our staff has some work, some more work. Okay, so we'll work on getting some of these other policies up to our meetings and get some discussion on them, and we're going to allow our staff to have the time to put these together. And once they get it together, then they can bring it back to us, and we can get started. So as long as we don't have any policies that we have to have, then we will bring those forward. But if it's something we have to have immediately, then we'll have to get that taken care of. Okay. Any other questions or comments before we adjourn? Any questions or comments from anybody? Staff? Board? Nothing? Okay. Well, thanks to everyone who was watching the meeting, and we at this point in time, we're going to adjourn. Thank you again. Have a good evening.